Hello, this is Stephen Houghton again with the 1215 Project. So I'm moving on to my second video in my attempt to go through the Constitution in order and discuss its meaning. And so for this video, we're going to discuss Article 1, Section 1, the first substantive words of the Constitution, which reads, "All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives." So that seems fairly clear, obviously, right? But you look at the words and you say to yourself, well, okay, all legislative authority is vested in Congress, and Congress is made up of the House of Representatives and the Senate. But there's a lot of background on this section that needs a little fleshing out, maybe. The first thing to remember is that this is a clause with history behind it. When it says all legislative authority, what it's referring to, what it's forbidding, speaking against, is an older idea in the Anglo-American government tradition, which was an idea that many of the kings of England had, which was that they had a right to rule by decree, by proclamation, to make laws. And everyone agreed that the kings of England could make proclamations, like a proclamation saying, "There's a disorder in thus and such town. I bring to mind, to your attention, the following statute which forbids the acts that you're taking. If you don't do this, if you don't stop within 24 hours, then we're going to start arresting you all." That was the sort of proclamation that everyone agreed the king did have a right to do, to remind people of their legal duties before then using state force to punish people. But there was another idea of proclamations, which some of the Stuart kings, especially, also some of the earlier kings of England, too, Henry VIII, trying to get Parliament to pass a law that said that his proclamations had the force of law. They were very clever. They passed such an act, but said, unless the king's proclamation shall basically affect the rights and liberties of his subjects. So sort of, we'll give you that power with one hand and take it away with the other. But the point here is that the Stuart kings really did make a serious attempt. They started publishing their proclamations as if they were law that could be appealed to. And so that was a big part, obviously taxation and so forth were other issues in the struggle with the Stuart monarchy. But the key, one of the keys, certainly the most important one here, was the question of legislative authority. And that in England was finally settled. There was one legislative authority in England, and that was the Crown in Parliament. And when we started our system of government, basically that is the answer that we took to. In the sense that you might say, but we don't ever speak of the Crown in Parliament, or we don't speak of the President and Congress. But because, as we will come to later in this discussion of the Constitution, because the President has a limited right to veto, there's a way in which there is a similar thing. Obviously, it's not the same because Congress can pass laws over the President's veto, and therefore the legislative authority really is vested in Congress alone, as in fact the text here says. So what's important about this is that people seem to have totally forgotten what it says and the purpose for which these words were included in the Constitution of the United States. Now, obviously, the second half about the House of Representatives and the Senate imposing Congress, that has a different purpose. That's to point out what Congress is made up of. But the first part is to say that there's one source of legislative authority, and not just source. the source of legislative authority obviously is in the people, but there's only the legislative authority that is granted by the people to the government of the United States is lodged in one particular place, and that's in the Congress of the United States. And we can say it's in one place alone because it says all legislative power herein granted. Now, if all power is in Congress, then there can be no other source of legislative authority anywhere in our constitutional system, in our federal constitutional system. Obviously, the states have their own independent legislative authority. So, what are the implications of this? Well, in Supreme Court doctrine terms, this is often, when it gets discussed at all, this is called the non-delegation doctrine. The idea that that Congress is not allowed to delegate legislative authority to the executive. Now, unfortunately, in practice, since the 1930s, basically, this has become a nullity. But I think it's important, that is to say, the courts allow Congress to delegate their authority to the executive all the time. And in fact, this is a big part of, some current problems we're having. The current president with his attempt to dispense people from having to pay part of their Social Security taxes. Whatever one thinks of the idea of suspending the Social Security tax to get the economy going again, which I personally think is a pretty good idea. But the president doesn't have the power to dispense with the law anyway. But so I guess that's not strictly speaking delegation. But take DACA, right? Because that really was, he claimed he was using that this was just an example of him using his power to, as chief executive to prioritize law enforcement. And if he had only done that, if he had just told all of the people in the federal executive, we're not fucking around with this enforcing of the immigration laws, we have more important things to do, that would have been fine. But of course, DACA is something totally different. It basically said, if you sign up with us, we're going to not prosecute you. Well, in that, he's trying to bind future executives, but he can't. But that basically becomes a form of legislation, right? And I don't need to pick on President Obama. I mean, there are hundreds of examples of Congress passing laws and basically saying to the president, well, you figure this all out. Which, of course, one of the problems with this is it totally undermines any accountability in the legislature. I mean, if the legislature basically just passes laws that say, do nice things for the environment, help employment, and then the executive will figure out what that is. Well, everyone's in favor of a nice environment. Everyone's in favor of full employment. But, so who could be against that? But then they get to be cheered for being in favor of good things, motherhood and apple pie and all that. But then they don't actually have to, when the pie has, glass shards in it, they are like, that's not our problem. The executive did that. Well, first of all, the executive has no power to make laws. All legislative power is vested in Congress. And so, first of all, as I say, it's unconstitutional. And second of all, it creates a serious problem with the legislature just not taking any responsibility for the acts that it passes. So, I guess we've talked a little bit about the history, a little bit about some of the consequences, the fact that this is not, unfortunately, the way our government is working at present, and I might add, I think is a huge part of why, there is a certain skepticism in a way that has become very widespread, especially in the younger generation, over how much authority the people really have, how much power they have in electing members of Congress. Now, I certainly can't go into all of our problems with polarization and everything, but there's a real way in which this is a big part of that problem, right? If Congress has, gives all of its authority to the president, well, what's the purpose of Congress then? I guess to be, a complaints bureau for citizens, maybe. Anyway, so I hope that you all found that a little bit enlightening. I didn't write this out the way I sometimes try to, so we'll see how it turned out. Anyway, have a great day, and I guess my next video is going to be on Article 1, Section 2. Have a lovely day, and God bless you all, and stay safe. Bye-bye.